Thank you, everybody. As you know, my program material is actually set forth in the syllabus. There's an excerpt in there regarding the Levine versus Wyeth, as well as the unpublished manuscript involving pharmacist's duty to warn. Understand I'm talking about duty, not responsibility. Obviously, there's responsibility of pharmacists to always consult and warn with regard to the patient, the doctor, or whomever. But just a note with regard to the Levine versus Wyeth case, if you look at footnotes 4 and 5, I set forth essentially some pertinent information that healthcare professionals would be interested in that case, not so much the legal point. But in the product circular itself, it does warn of inadvertent intra-arterial injection, and it further warns that if there's pain on injection, it should be stopped. And it can result in severe irritation and subsequently gangrene and amputation. So it wasn't the situation where the statement was in fact made. In fact, the product circular recommends that it should be given by intravenous infusion. And understand that in the Levine versus Wyeth case, the warning was to the healthcare professionals. So as healthcare professionals, certainly that is understandable, perhaps not so much to the patient itself. Intra-arterial, for example, is not necessarily a common word. But notwithstanding that, the medical doctor in this particular case had the physician assistant give the particular drug and the particular method, the IV push, which created the issue. Yet there's no record in the case itself that the doctor informed the patient of the risk or obtained the consent or waiver, which is an interesting point in light of the fact that we're talking about duty to warn. Nor did the doctor, in fact, warn or train the physician assistant with regard to this particular procedure and with regard to this particular drug. Traditionally, in a medical proceeding, if you have a senior doctor and a junior doctor, and you ask the junior doctor to do something in particular, or a junior pharmacist to do something particular, there's something particularly critical about it. For example, there's a drug called, immunosuppressive drug called Celsepid, which you can mix in oral solution for pediatric use. Pediatrics, for example, can't take pills, for example. But it has a unique warning that you have to wear gloves when you mix it. So if you ask a young intern to go ahead and mix it and you don't warn them about it, you need to ask yourself, where does responsibility lie? And in this particular case, in Levine, as you may recall, if those who read the case, the patient did complain of pain, that the physician assistant continued to do that, continued to go forth with procedure. So what I would say is that this case was sent before a jurors of pharmacists and doctors. I can't necessarily say, at least for the trial record, that the result would be the same. But at any rate, we're here for the pharmacist's duty to warn. As you can see, the implications of what's going on, particularly the side effects and the dangers of the drugs itself, it's very important that this is so. As you can look at my material, the materials are quite extensive. You have a chance to read it. I'm not going to go through all of it, obviously. But as we all have learned already, the learned intermediate doctrine, the drug manufacturer has generally no duty to warn the consumer. The exception, of course, as indicated by earlier speakers, the direct advertising or promotion, particularly where there's overpromotion. The manufacturer does have a duty to warn the physician of potential risk of drugs, and that's a very important part, since the majority of the literature is directed to the physician or healthcare professional. In general, pharmacists are generally shielded from negligence actions for failure to warn, and under the learned intermediary doctrine, pharmacists have no duty to warn the consumer of the potential danger of prescribed medication. That is evolving. This is what this article is in part about, due to the change in pharmacy, the education profession, and the medical field in general. In terms of education, the terms of education has gone from 5 to 6 years to as many as 8 years now with fellowship and residency. With regard to the medication, pharmacists in the past used to be the mortar and pestle type people. These are the guys who used to mix and do the recipes, the so-called chefs. And in time, it has changed. It has changed in the sense that the drugs are much more complicated now. There are many more generics. And understand with regard to the generics, unlike food products, which now in many places you must label where the source is, you don't know where the generic came from. And those who read the literature understand that foreign manufacturers of drugs in the past have had real trouble with contamination since their factories have not been inspected. The 2 points, one of obviously the heparin issue was a problem, and the dog food veterinarian case. The pharmacist does have a legal duty to properly fill a legal prescription, must be alert for clear errors and mistakes. If the doctor writes the wrong dosage, you look out here, you see a child in the doses for an adult, you obviously have that obligation. And the pharmacist must warn the patient of obvious inadequacies in the face of the prescription, or particularly excessive overdose. The dosage, one thing about, when I'm talking about dosage, you must understand that dosage involves a lot of type of things, both retail as well as hospital. In a hospital setting, when something's given intravenously through a vein, the effect is immediate and can be catastrophic. Normally, if you take an overdose of an oral medication, more commonly you would just have diarrhea or something like that. it is not also necessarily fatal. There are some oral drugs that have what is known as a thin therapeutic a margin of error, digoxin, warfarin, some of these, the blood thinners, the heart medicine, these are the things that are the problem. One of the reasons why there's not a common law duty to impose, as it's been expressed in the courts, and all the cases are cited in the document I submitted, is the imposition of the duty to warn the pharmacist to interfere with the physician-patient relationship. The pharmacist does not select the drug prescribed. Physician has superior knowledge and intrudes on the privacy of the patient if you want to learn about something. For example, you get a particular drug and you know that there's a particular problem with the drug. You need to talk to the patient and ask them, what do you have this? How much do you weigh? Do you have a problem with kidney functions? Let me see your lab values and see what's going on. So, and a lot of people have gone to retail pharmacies, I'm sure, it's not necessarily the best place to discuss these personal matters in sort of a public setting. And then places upon the burden to retain all the information. Anybody's ever done a Lexis site or Medline search, even in law, there's just so much stuff now. And on top of that, if you ever read one of these circulars, the circulars have so many items in there regarding the side effect that scare the death out of you. I mean, if you listen to even the stuff that's advertised, it's only the simple things, and they only put down 3. But if you actually read the circular, it runs in pages in very fine print. And basically, what the basic argument is, duty should be imposed by the legislature. But nonetheless, the courts have held that pharmacists do an owe duty beyond accurately filling a prescription. And it's particularly when the situation is when the pharmacist goes beyond the normal duty, or there are things going on. For example, in advertising, if I advertise that, listen, you come to my pharmacy, so I'll take care of you, I have a full profile on all your medications, tell me what you're taking in OTC drugs, tell me about your herbals, and I'll give you full information. If you do something like that, then you're asking for to be imposed upon a legal duty. And also now with regard to the fact that everything's computerized now. There used to be drug information services in hospitals where the doctors or the interns or pharmacists would call to get certain information regarding obscure facts. But now, as they say, Google's taken away that away. You can pretty much look up everything. The problem with the internet, obviously, is the fact that the issue of reliability. You're reading it without the background and without the experience. And the most critical part, I must add, is the experience and understanding and reading these documents. It may say certain things, but this may not be applied to you, or there are a lot of exceptions, or the particular literature is not any good. If you ask about allergies, for example, particularly penicillin is a particular problem. Most pharmacists do ask about allergies throughout the state. If you put down allergies in your computer model, you of course have to be aware of it. And it's not just penicillin. Penicillin has a lot of related drugs, including cephaloxins, these kind of drugs, Keflex and things like that. So you need to be aware of that. And nowadays with the computer model, all these things are popped up on the machine. Particularly now that many of us belong to HMOs or PPIs or other things where the so-called medication record is centralized. In the past, we may go see one doctor for this, one doctor for that, and they may not necessarily belong to the same medical group. So the information is not necessarily collated in one spot. Any voluntary assumption of duty creates a particular duty, and such that you owe a duty with regard to high dosage or overdosage, or if you're providing a patient with a list of warnings regarding the drugs, you need to provide a certain amount. In this regard, the FDA has put out what is known as approved medication guides now, which set forth essentially the primary information that the pharmacists, the doctors, or whoever who dispense drugs must circulate. In addition, many of you people who go to drugstores also get what's known as a PPI, but it's a personal patient information sheet which sets forth a lot. And I'm sure if any of you have read it, I'm sure you've been scared to death too. And it's an interesting point that if the pharmacists do consult, you must understand that a pharmacy is very busy as a general, particularly those that are selling drugs at $4 a whack. You're talking about, you don't need an economic degree to understand that there's not much of a profit margin. So you need to move along. The pharmacist has to move along in terms of getting it filled. And in that second of filling that prescription, the analysis in the pharmacist's mind has to be very quick. You have to not only know that drug, but you must know the drugs that the other person is taking. You must be able to read the information on the particular information sheet that comes out. And so you must be aware of what is going on immediately. If there's a particular problem, an allergy, the only way that works now is you have to override it. So you have to be very careful about overriding it. But in the consultation process, understand you're on the line. So I'm standing there consulting you for the next 30 minutes, and the guy behind me is killing you. So the idea of this thing here is a consultation, even though this consultation is very short. And many of you have gone to doctors, and you know exactly what happens. You go there for 15 minutes, you talk about a thing. You never see the chart, though. The medical chart may just say that no complaints. You may have said 10,000 things, but you understand the chart is not a verbatim transcription of what occurred. And with regard to the side effects, I think from your own experience, you know that not a lot of it's discussed, just the general ones. And sometimes the general ones are very, very apparent, so you would complain. The problem is these so-called rarer ones that come up, you may not even realize that it's caused by the drug. But at any rate, the duty to warn has essentially been, has come about in good part because of the Medi-Cal Act, which requires consultation. This is just in 1990, and the OBRA regulations. But these regulations, however, do not create a duty, they create a responsibility. There are cases which I cite that doesn't necessarily find that there's a legal obligation to do it. And there are many state regulations that have different things, including giving warnings. For example, California, you have to indicate those prescriptions where a combination of alcohol would impair the person's ability to drive a vehicle. So that's an actual requirement. And there is a duty in California to consult the consumer. And understand also that there's a unique issue with regard to the dispensing of oral contraception. It plays into the religious rights, R-I-G-H-T's, in the sense that a pharmacist does not necessarily have to dispense it if it's against his moral judgment in California. You would, however, must give advance notice to your supervisor that you are of that ilk. And also you must assist the patient in seeking other avenues upon obtaining this particular drug, particularly like what they call the Plan B, which is essentially an abortion drug. With regard to this matter here, I don't have much more to say. The only thing I need to note is that there's an upcoming discussion with regard to the contact cases, the California case out of San Francisco involving Reglan and tardive dyskinesia. In February 26, 2009, there was a black box required by the FDA. And I will conclude my discussion. Thank you.